Hello and welcome again to Immigration News and Views. My name is David Nachman and I'm one of the managing attorneys at the Nachman Pawani Zimochek Law Group with offices located in northern New Jersey, New York City, and we also have affiliated offices in Canada and also in India. And with me today is Ravindra Singh, and Ravi Singh is an attorney in the state of New Jersey, and he works with our office, and we have recently done a series of articles with the great help of Ravi to describe, no problem, to describe to our viewers a little bit about the H-1B, because we know that obviously, there's a lot of information out there on the web, and sometimes consuming that information is really difficult. So Ravi and I were speaking, and we thought it might be really helpful to do a video where we can just sort of have a discourse about H-1Bs and about some of the issues that you may need to know about. So what we're going to do is we're going to do this in a series of videos. This is going to be the first in a series of many about the H-1B, and what we're going to try to do is we're going to try to post them coincidentally with the articles that we are posting on the web about H-1B. And so I think that what we probably need to do, Ravi, is to try to figure out what would be a good area of interest, one of the first and most important issues that might be of interest to our viewers. So, what do you think? Yeah.
I think let's talk about the numbers of H-1B visa that is allocated by the Department of State every year. So, David, you want to talk about it?
Well, the numbers are really important, and I think, Ravi, it has to do with the designation of H-1Bs that are available. And historically, what happened was before, and I was practicing law before 1990. There was no limitation on H-1Bs, and we could do as many H-1Bs as we wanted, and that was really great. But things changed in 1990 under what's called IMACT 90. Which actually became law in 1991, and there was a cap that was placed on the number of H-1Bs, and that H-1B cap was established at about 65,000 H-1Bs that are available, and then and actually some of those are allocated toward.
That's right, David. Some of these visas, like 6,800 visas, especially for H-1B1 program, that is specifically designed for the citizens of Chile and Singapore. So that leaves the rest of the world with only 58,200 visas. But there are like 20,000 additional visas that Department of State allocates to the applicants who gain like an advanced degree from any United States educational institution. People going for master's degree normally qualify for the additional 20,000 visas.
Right, and those master's degrees that they have to have are U.S. master's degrees. It's not that they can have a master's degree from abroad. So, whereas if you have, if you're looking at getting an H-1B that's subject to the cap, then of course, or any H-1B, then of course you have to have what's called the equivalence of a baccalaureate degree. Which can be shown in several different ways. One is that the individual has the baccalaureate degree, or two is that they do an evaluation, an educational evaluation equivalency, or three is they can use what's called the 3-to-1 rule, which is set up in the regulations, where 3 years of professional level work is equal to 1 year of academic.
That's right, and especially that's important because most. If we are talking about somebody coming from India, most of the bachelor's degree from India, they are like 3 years, unless you are going to a 4-year degree program that is like applicable to most of the engineering students. But if somebody has a Bachelor of Science degree from any of the universities like University of Delhi or maybe from University of Calcutta, then the person needs to add on the educational, the work experience in order to substantiate for the 1 additional year of education.
Exactly, and the way that would be done is through some type of a qualified credentials evaluation service, which would be able to issue an expert opinion letter that says that the academic plus the work experience is equal to the equivalence of a U.S. baccalaureate degree. And if any of our viewers are interested in the names or contact information of one of those equivalency evaluation services, please feel free to reach out for us by email at the email address on the screen. Probably at the end of the video if it's not on the screen now, and we'll be more than happy to provide you with these equivalency evaluators. Some of them are very, very good in their field, and some of them actually are not so good. In fact, recently we've received some RFEs, RFE being request for evidence after the H-1B is filed, where the government has come back and asked about the quality of the evaluation service,
That's
right?
right.
So, and I'd like to circle back around to one of the really excellent points that Robbie made, and that is that there are a certain number of H-1B1s, which are Singapore, Chile. And one of the things that you need to know about those Singapore, Chile H-1s is that those are not dual intent. Those are not dual intent H-1Bs. So just be careful with that in case you're thinking that you can go to the green card from that H-1B, because usually what you can do is you can use that H-1B, get your time, and then maybe go into the normal H-1B cycle and do a normal H-1B. Then when you have the dual intent classification, then you can go off to the green card.
That's right.
So don't be lulled into any sense of false security, thinking that that's going to give you the dual intent that you need. So what else should our viewers be concerned about, Robbie? Some other issues.
Let's talk about the control issue that has been going on, and it's very hard. Again, every employer who is sponsoring an H-1B needs to show that that the employer has sufficient control over the H-1B employee or the prospective H-1B employee.
Right, and actually let's take a step backwards and just talk about the history of that. What ended up happening is back in actually 1997, 1998, 1999, 2000, with the Y2K issues, it developed an industry with, an industry was developed mostly of Indian consulting companies, where what they did is they created what are called body shops, sometimes referred to as head shops. I like body shop more. And what they do is they send people out to site. And that's okay, you can do that. But if an individual is being sent out to the site, it's really critical that those individuals maintain the employment relationship with the H-1B petitioner. And so, Robbie, what are some of the ways in which we can prove that the employer has that control over the individual? What are some of the ways that we can prove that?
I'll start with the conclusion. The employer needs to show where, when, and how it's controlling the H-1B employee. So if you are an IT consultant and you are working at a secondary work site, then your the primary employer who filed for an H-1B needs to show how you are being controlled by your primary employer. What I want to convey is you should have somebody managing you while you are doing work at the secondary work site location. Then the tools, like the software you're using, the laptop you're using, any kind of gadgets that you're using there, and they should be provided by your employer. Then you should not be reporting. You could report to the manager who is there at the work site from the client's end, but then primarily you should report to your primary employer.
Exactly, and so some of the things that you can do, and our viewers need to know this, is that there are ways to document clearly this issue of control. So one of the things that obviously we would want to certainly make sure of is that the payroll is coming from the petitioner of the H-1B, the petitioning company. So that's number one. Number two is we'd also want to have independent contractor agreements, probably between the parties, to make sure, or some form of agreement, maybe an employment agreement. I don't know that an employment agreement necessarily is done by every organization, but obviously an employment agreement helps to manifest that control. And other things are, for example, if the individual is filling out time slips or a timesheet, that timesheet comes from the H-1B petitioner. And so what you can do is you can prepare timesheets with the H-1B petitioner's name on it, and just that is a way to demonstrate control.
So one more thing I wanted to introduce here is getting a client letter from the client's from the end user is very effective in avoiding a potential RFE, because once your primary employer submits an H-1B petition to the CIS, the CIS will come back and ask you, okay, you have filed, okay, for a petition, and now you prove how you are going to manage to get this employee, okay, at the end side. And so in order to avoid that, to have a client letter before you submit, okay, or when you are planning to submit an H-1B petition, that's very critical.
So thank you very much for being with us. We certainly appreciate your tuning in today. Again, as we said, Ravi and I will be back. We'll be doing more videos on H-1B issues, and we hope that this information is of great assistance to you. Again, if you have any questions at all, please feel free to direct them to either me, info@visaserv.com, or you can send it to Ravi. It's Ravindra_Singh@visaserv.com. Ravi, thank you so much for being with me, and we look forward to seeing you again soon. Bye now.